Steve, I think there's an audio. All right. Good evening, everyone. Welcome to the third in the series of Know Your Institution at the MCIA ADR Week 2023. We have on the panel with us the people behind the most prominent institutions around the globe. And this panel, I can safely say, represents some of the very best which arbitration has. What I will start is the introduction of my panelists. And I'm Samir Jain. I'm your host and the moderator today. We have on our panel Steve Kim. Steve is the Secretary General for the Korean's Commercial Arbitration Board. He's previously served as the Director of the American Arbitration Institution from 1998 to 2005. He joined KCAB in 2022 and has brought with him a sense of commercial approach to the arbitral institution. We then have Vivekananda Neelakantan, fondly known as Vivek. Vivek is the head of South Asia and Deputy Registrar at the Singapore International Arbitration Center. He leads SIAC's inaugural overseas office in Mumbai and also basically is the face for SIAC in India. Vivek has his degree is law from India, has worked in multiple law firms. He was a partner celebrated in Jain, Singapore, and brings with him a wealth of both user experience and the administrator's experience. We then have on our panel Ms. Alefiyah Shipchandler. She's the Deputy Counsel for HKIAC. She holds an LLM in International Dispute Resolution from Geneva and has, again, an experience both in a disputes firm and the institution. And that brings with her a wealth of experience in arbitration, specifically international commercial arbitration. We also have Deborah Tomkinson on the panel. She just retired as Secretary General for the Australian Centre for International Commercial Arbitration and now has gone into the practice of arbitration. She's a celebrated lawyer, an experienced arbitrator, and a counsel. And we have with them an august panel which can really speak about the uniqueness of the institutions and promoting the world of commercial dispute resolution. I do understand we have around 30 minutes for the session, and the way we would want to run this is I'll ask one question from each of my panelists, which will be unique to with their perspective. And if time remains, I would want to run some rapid fire questions to all my panelists. I'll start with Steve. Steve, we heard that KCAB has a new chairman. And how do you think that this change will take KCAB's growth in 2025? What plans does the institution have for the next year?
With the approach that we have taken so far, and as I mentioned to you in my short bio, that for the past 2.5 years, I took a very commercial approach, meaning that I wanted the clients to actually be attracted to the institution for the practical knowledge and the information that we could offer to them. Simply because we have the network of professionals and the experts that we could actually provide to our users in almost every industry and every aspect. With the introduction of the new chairman that came on board, we can now take that to the next level in a more systematic level, meaning that he's now able to acquire additional budget. We can now hire more people. So we now actually go into a growth phase, and we actually could complement that with the same aggressive nature of marketing and sales approach, which we have taken for the past 2.5 years. So I think that's the biggest change that you're going to be seeing from us for next year.
That's excellent. So that essentially means that we'll be looking at a lot of growth initiatives.
That's correct.
Institution.
Exactly. You're going to be seeing a lot of us everywhere, including India.
That'll be fantastic. Looking forward to that. Thank you. Moving on to Vivek.
Right.
Vivek, as you're aware, SIAC is the most preferred institution for Indian multinationals and Indian corporates to resolve their dispute, and so is Singapore. Why do you think that's happened, and what is your institution SIAC's role in attracting the Indian dispute resolution users to SIAC?
Thank you, Samir, and thank you for having me here. I think the short answer to that question is simply that Singapore is India's most efficient and cleanest city. And there is some truth to that statement, given the comfort that Indians feel in Singapore on a general basis. But I think on a more serious note, every single thing that is done at the institution, that is SIAC, in terms of how the rules are structured, how the processes are structured, how the procedures that we've created along the years have been put in place, have been created with the idea of answering three simple questions that every user in international arbitration faces: is how much is my arbitration going to cost? How long is it going to take? And am I going to have an enforceable award at the end of that process? So much of what you see in the SIAC rules, in terms of whether it's the expedited procedure that was put in place way back in 2010, the emergency arbitrator procedures, which was again put in place way back in 2010, and I've seen so much use by Indian parties, the early dismissal provisions, and even the manner in which tribunal fees are determined by SIAC on a relatively objective basis, based on the actual work done, not necessarily time spent or hours spent. And lastly, the scrutiny and review of awards that SIAC carries out. All of this is intended to answer those three questions and ensure that there is tight oversight over timelines, there's control over costs, there's certainty and transparency at the outset, and you have an enforceable award at the end of that process. So it should therefore, I think, come as no surprise that at the institution, at SIAC, we've administered over 1,400 cases involving Indian parties in the last 10 years, involving more than 2,400 parties. But more importantly, in the last 12 years, based on our own review of reported judgments from the Indian High Courts and the Indian Supreme Court, no SIAC award has been set aside or refused enforcement in India ever in the last 12 years. So, and I think that's again testament to the kind of processes and procedures that the institution has in place, which are intended to be catered to Indian parties. Last but not the least, of course, I think Singapore, in the manner in which it has developed its jurisprudence in relation to international arbitration, the approach of minimal curial intervention after an award is made in setting aside applications, has been very attractive for many parties who are looking for that finality. And of course, this includes Indian parties who are quite often on the claimant side as well, and the winning side, you know, in an arbitration. Add to that, of course, I think the liberal regime that you have in Singapore, with so many Indian lawyers practicing international arbitration at their sides, including yourself, Samir, who has not only been in arbitrations in Singapore, but has also been before the Singapore International Commercial Court, you know, in proceedings relating to arbitration. So I think the ecosystem is structured in a way that it is able to provide Indian parties efficiency and enforceability. And of course, I think the ability to participate freely through your own counsel in arbitrations. And I think that adds to the ever-growing experience at the institution with Indian parties. I'll pause there because, of course, I can speak about this till the cars come home, but I know we have a limited amount of time.
I think that's an issue which all of us will face in this, because we all want to say so much about arbitration in general. But you're right. I think it's the cost, time, and certainty, the three pillars on which you say it's, and of course, jurisdiction of Singapore as a very stable jurisdiction in arbitration. Very well. Thank you, Vivek. Deborah, my question next is to you, and in relation to ACICA. Since you have recently moved out, of course, the most natural question I have is, what will you miss the most about the institution? What do you see the institution future as? What is your wish list? And in this regard, would really love to hear from you.
Thank you, Samir. But there's a lot in that. I've been with ACICA for 12 years, and more than 10 of those were as Secretary General, and we've achieved a lot in that time. So I'm this is, in many ways, I feel like, you know, we've reached a lot of the goals that we had during our time, and I think it's now a really good opportunity for the institution to look at what it wants to now achieve going forward. It's been a privilege for me to be involved with a growth institution and the broader arbitration community in Australia, and to see so much growth in that time. The last sort of 5 to 10 years, I think, is where Australia has really started to make its mark in the international arbitration world. And some of that, I suppose, has grown from the exposure that we received when people attended ICA 2018 in Sydney. And they began to understand more about what the practitioners and ACICA as an institution really has to offer in this space. I suppose for me, some of the more recent initiatives that we've managed to get off the ground, including launching ACICA Connect, which is our online case management platform, some of the initiatives, the Diversity Committee and the Sustainability Task Force that we have recently started, and also our Pacific Islander Practitioner Scholarship Program, have been projects that have been really, really close to my heart. And I'm looking forward to sort of continuing my involvement with those in a different capacity. The sort of, I suppose, the biggest, most significant recognition for us recently has been the GAR Award that we had earlier this year for the arbitral institution that impressed. And that was a lovely sign-off, I suppose, in some ways for me. But I am really, really excited to see the institution go forward with the new leadership that we have in place. So Judith Levine, who most people will know is our new president starting this year. She takes over from Georgia Quick, who leaves an amazing legacy at ACICA. But Judith has been involved with ACICA since 2006. So she brings with her not only her incredible expertise as an arbitration practitioner, not only in law firms, but also at the Permanent Court of Arbitration. But she has significant historical corporate knowledge of the institution. We also have Diana Bowman starting as the new Secretary General, and she's a really fantastic fit with the institution. She's got national and international expertise, leading law firm practices across the world, as well as significant in-house experience, which is an incredible input for us to really start to work with and understand the end user experience. So while it's sad to leave always, I think having that leadership in place makes me sure that the institution's going to continue to grow.
Right. Thank you. And those are great initiatives, and congratulations on the award, and good luck to Diana for her stint now. Thank you. Thank you so much. Alefiyah, my question to you, of course, will be in relation to the recent amendments in the HKIAC rules. And since you are here, we'll probably would love to hear about the recent amendment in the rules, and if you wish to highlight anything important which you think is important for us to know.
Right. Thank you, Samir, and thank you to the ABI and MCIA for organizing this series. Now, as most arbitration institutions, HKIAC has always been extremely concerned about user satisfaction as far as its rules are concerned. And so the 2024 amendments to HKIAC's administered arbitration rules is a recent effort to better the existing set of rules for parties that are seeking not only procedural flexibility, but also cost effectiveness in their arbitration. And now the key sort of amendments that have been brought in this year can really be divided into 3 broad buckets. And the first is to do with your time and cost saving measures. So these amendments really go to a tribunal's powers relating to case management and really clarify the range of case management powers that are available to a tribunal to conduct an arbitration efficiently. So, that can include things like determination of preliminary issues and things like that really go to saving time and costs in an arbitration. And you also have the introduction in Article 31 of the rules, a deadline for tribunals to close proceedings. And this is now capped at 45 days from the last substantive submission. And so really the 3-month deadline for rendering an award starts running from that date. And so these are really the time and cost saving measures that have been brought in. But we also have the second bucket, which go to efficiency and integrity. And there are now explicit provisions in the rules which say that HKIAC can consider efficiency and integrity in arbitrations when we are looking at confirmation of designated arbitrators. And we've really seen the importance of such a provision when it comes to delays, perhaps in arbitrations or any other such things that lead to just proceedings going on for a very long time. And we also have revisions to our Schedule 2, where HKIAC also has now the ability to review an arbitral tribunal's fees and expenses and make adjustments to the fees and expenses if required. So it's a sort of check that has been brought in as far as arbitrators' invoices and fees are concerned. And the third and last bucket really deals with developments in international arbitration, and my personal favorite, which is Article 9A, and this deals with diversity. So it's an article that definitely requires HKIAC and encourages parties and arbitrators to take diversity into account when appointing arbitrators. And while HKIAC always had diversity as a consideration, it's now an explicit provision in our rules, and we've already seen the impact that such an express provision is having. And really, in addition to that, there are provisions with reference to greener arbitration and the requirement for tribunals to consider the environmental impact that arbitrations have, and a direction that they can take that into account when you're looking at adopting various procedures or even allocating costs. And you also have amendment in Articles 13.1 and 45A, which deal with information security, and also now an explicit provision for directions to be given to protect these kind of confidential information.
Right.
So
Lovely.
those are really, in summary, the
Yes,
amendments.
and I think most of these amendments are to catch up with the recent changes globally, and it's very, very nice to hear. On diversity and inclusion, I was reading, correct me if I'm wrong, in 2023, 34.9% of all appointments by HKIAC were women arbitrators. On that,
Right.
I know for a fact that most institutions are working hard and bringing in changes to promote inclusion, diversity. And I would request everyone to just probably take 30 seconds to highlight or to show as to what is that each institution is doing. Would anyone want to speak about? Yes, Steve, we'll go with you first, and then we can go to Vivek and then Deborah.
Sure. From KCAB International perspective, we start out at the arbitrator panel application level. So when we actually get the applications, the internal review team will actually give certain priority and preference to female, in particular, with female practitioners or arbitrators with technical background, diverse language, for diverse social backgrounds, and whatnot. So we start at a root level. To ensure that the panel membership itself reflects diversity. So that's where we start.
Oh, lovely. That's an interesting point. Vivek?
Interesting fact, about 75% of SIAC's workforce, which is the organization that is SIAC, are women. And that's, just the way the organization is structured. But talking about arbitration in particular, in terms of the cases we administer, yes, of course, I think gender diversity has always been an importantly tracked statistic, and that's publicly available in terms of SIAC's numbers. But I think added to gender diversity, there's also the need for national, ethnic, and other kinds of diversity. And interestingly, last year, Indian arbitrators, for instance, were the third most appointed nationality in SIAC arbitrations.
Right.
And equally, I think we do a fair amount to appoint younger arbitrators, people who are younger in their arbitrator journey. So I think diversity must, I think, always be considered in a holistic fashion is the way we look at it.
Of course. Deborah, your
Thanks, Samir. I mean, I completely agree with Steve and Vivek. I mean, we look at diversity across the entire institution. So it's not just the Secretariat and the board, it's all of our committees. It's all of the different task force that we look at. We also look at it for all our events and conferences. It's incredibly important that we have diversity across the speaker pool. One of the initiatives that we've run really successfully over years has been an International Women's Day outreach program, where we've actually looked across the arbitrator panels throughout the institutions across the world, and we've reached out to women who have diverse backgrounds and who we think would be great on our panel as well, and we've directly invited them to apply for the ACICA panel, and that has lifted the number of women as well as women from diverse backgrounds on the ACICA panel, which is really, really important.
Thank you. Thank you, everyone. I think it's very hard, very nice to see that every institution is working hard to bridge that gap, and it's really showing in the industry and globally. That brings me to the last section, which is the rapid fire. I will ask about 3 questions from everyone and probably 10 to 15 seconds of an answer. Vivek, I'm going to start with you.
Sure.
What attracted you to SIAC?
I think it's an opportunity to shoulder a unique responsibility sitting at the institution as opposed to in other, I think, careers in law, in arbitration.
Nice. What's the top challenge faced by global arbitration community today?
I think ensuring consistency of professionalism across the board, counsel, arbitrators, parties, other service providers.
Okay. And in one sentence, describe what makes SIAC the go-to choice for arbitration.
I won't use a sentence, but this is our ethos really is efficiency, excellency, enforceability. That's the focus for the institution.
All right. Thank you. That was great. You fared very well. Steve, next is you.
Sure.
What's one key factor that has contributed to South Korea's growth as a hub for international dispute resolution?
Technology. We've always been very keen on developing technology, and that's what resulted in national growth, and that's actually what's prompting and propelling the arbitration market here as well.
Nice. And what's the one most important skill for a successful arbitrator?
Time management. So it's easy to be roped into, and with very experienced counsel on both sides, to basically be delaying the process or trying to buy as much time as possible. Time management is the key.
All right. And if you had to describe the future of international arbitration in one word, what would that be?
Commercialism. That is exactly where we need to go.
Okay, lovely. Deborah, I would now ask you the rapid fires. What standout transformations at ACICA have caught your attention during your tenure?
Sorry, standout.
Transformation at ACICA has caught your attention during your tenure.
I think the standout transformation has been the growth in visibility and capability out of Australia. So the return of practitioners from overseas, the growth of the institution, and the extensive expertise that we're seeing across the court system as well as the legal practitioners.
Okay. And what's the one arbitration trend which you think is a total game changer?
Oh, well, I think this goes back to our earlier conversation. For me, I'm a strong advocate of diversity, and I think the changes that we're seeing in terms of the real diversity in all areas in arbitration is the game changer.
Okay. And last one, with your role having changed and your role having shifted, what is the one key difference which you experience in your current role as vis-a-vis your previous role?
I think it's just a slightly different focus. Working in an institution is a very particular role, and you have that incredible benefit of being neutral. Moving back into private practice, you don't necessarily end up being able to be that neutral, and I think that's a real advantage in the institutions, is you're able to speak to people from that perspective.
Great perspective. I think that's true. Thank you, Alefiyah. What's that one thing you wish more people knew about arbitration?
Perhaps that the cost of arbitration is not really coming from the institutions. And if you're looking at costs of arbitration, you need to be looking somewhere else.
Yes, that's actually true. And what's one trend you're seeing in South Asian arbitration? What's that one striking difference or the new thing which has come up?
I think especially in India and yes, South Asia in general, there's the drive towards really structuring the arbitration practices and aligning it with international practices. So everything to do with the move towards institutional arbitration, but also making sure awards are enforceable and you don't get stuck in court.
Okay. And what's one key insight you'd like to share with aspiring arbitrators about arbitration?
Perhaps that arbitration really was meant for the end users and to solve commercial disputes, and maybe we need to shift our focus back to the true purpose of arbitration and concentrate on that.
Okay. Thank you. Thank you so much. I have one last question, and I think I'll address it to the whole of my panel. And each one of you can give your point on that. What's the most common misconception about arbitration? And I'm sure everyone will have either one answer or different answers for this question. We can start with Deborah.
I think it's a misconception that anyone can do it and do it well. Yeah,
I think that's hitting the nail on the head, actually. Vivek?
That is meant for complex, sophisticated kind of disputes only that are cross-border. Actually, it can be used in multiple situations very effectively.
Right. A lot of people have started to use it, but a lot more need to use it for their normal dispute resolution. Steve, what's that one common misconception?
Arbitration is not about splitting the baby in half. It's not about settlement. It's an actual enforceable adjudication of your issue. That's what people need to know.
Oh, lovely. Alefiyah?
I would actually echo Steve to say it's not always about being adversarial. And I've always been told, the arbitration went well where both sides go home unhappy. So, yeah.
That's true. Okay, with that, I think we have just finished on time, and I would like to sincerely thank my panelists for joining in, for sharing their views, MCIA and ABI. Thank you very much for taking out time, and it was lovely hosting all of you.
Thank you.
Thank you very much.
Thank you, Samir. Thank you.
Thank you, MCIA.